So cold. I can't even think straight, man. And I can't put it on charger because I'm using the way I strategically put it. The charger will not.
Good evening, everybody, and welcome to the program, The Law in Africa. Thank you, everybody, for joining us on Facebook and on our social media platforms. This is the Law Society, and this is the program, The Law of Africa. This program needs to discover and explore the law in Africa. And then today, if God wills, we shall be traveling and journeying to the southern nation of South Africa. We've got a lot from South Africa. We've learned a lot about the culture of South Africa. We've heard their music. We've seen their culture. Today, we are taking a different angle. We shall be going and looking at the laws. I know this will be interesting because we have two great men who are joining us to help us discover and explore the legal system of the Republic of South Africa. I am your humble host, Mohamed Wurie, and I hope and wish you will enjoy this program as I'm joined now by legal luminaries, I will put it. Mr. Guys, the names are very, 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 very hard to pronounce. So I'm going to allow you guys to introduce yourself. So the floor is yours now. Come on, kindly introduce yourself to viewers.
Yes, Mohamed. Thank you. Firstly, I'd humbly take this opportunity to express my gratitude and also my on behalf of my friends, on behalf of my friend, my gratitude. This opportunity couldn't have came at a better time, whereby the whole world is actually going visual. Okay, my name is Sakhile Mpanze. I'm a student of law at the Tshwane University of Technology, and as you said, today we will be assisting, or rather stating few facts regarding the South African legal system.
Okay. Katlego, Arnold, Mashego, kindly introduce yourself to people.
Okay. I guess it's evening now. Good evening, everyone watching. Thank you for tuning in. My name is Katlego Arnold Mashego. I will be presenting with my Leonard friend Sakhile, or Pagamani Sakhile Mpanze. Yes, let's stay tuned and enjoy, and I hope we learn something out of this. Yes.
Thank you very much, Katlego, Arnold, Mashego, and Sakhile Mpanze from the Tshwane. Yes, yeah, you're gonna pardon me with the pronunciation. For us here in the West, we have funny names, and it's quite difficult for us with our accents and to pronounce your names properly.
Not a problem.
I beg your pardon for that. It's I guess it's 11 o'clock in Johannesburg, in Gaborone and the surroundings, and also it's 3 o'clock. I'm sorry, 12 o'clock in Nairobi, whereas it's 9 o'clock here in Freetown, Sierra Leone. We are broadcasting live from the citadel of academia, the mountain of hope, once known as the Avings of West Africa, Frabe College, University of Sierra Leone. Welcome again to your weekly program, The Law in Africa. So as I've stated earlier today, I'm joined by two fine gentlemen from the university, the Stwani University of Technology. I stand to be corrected. So today we're going to take a slight shift from our normal way we do things in this program. So I will start firstly and foremostly by bringing you Katlego Arnold Mashego to do a presentation for us. Whilst from there we go to Sakhile Mpanze, then before we come to the dialogue proper. Thank you very much.
Yes, Mohamed. So
Yes.
what we had planned with my Leonard friend is that we will swiftly give a brief introduction,
Okay.
or rather presentation,
Okay.
before we allow questions.
Okay.
So
Guys, the floor is
we
yours,
had
guys.
we had agreed on
Yes.
that we will both entangle different aspects of the presentation, and then together we bring it together. I will be focusing more on the historical part of the legal system, how it emanated until this very sphere.
Yeah. Okay.
So the problem we've always had with the state of South Africa is that history in this country is fundamentally white, and it's Eurocentric in nature, you know, simply because most of the time it has been told through the perspective of the victim, you know, and it's always been difficult to grasp like the fruitful juices of our history, you know. We can go as early as the 1870s, you know. You would history would give you that human rights and the entire movement is Eurocentric in nature, you know. But if you would go deep into archives, I can refer you to a book written by Advocate Ngogaitobi, The Land is Ours, South Africa's First Black Lawyers and Constitutionality. There you will find famous or rather non-famous South African intellectuals. I would name a few: your Henry Silver Williams, your Alfred Mangena, your Dr. Kissel Sam. Those are the few individuals that kind of molded the legal system that we currently enjoy today. We can date back to the 1870s, whereby the first notion of an unbiased judiciary was introduced to this it was introduced by none other than he was one of Africa's or South Africa's renowned journalists, Ubabu Jabavu. He introduced the idea or ideology of an unbiased and fair judiciary, you know, mainly because back then judiciary was compiled of white individuals, meaning it was selective, and it was segregational, and also biased, obviously, to the natives, and it was positively beneficial to the whites, to the colonials. And then leading straight to, I don't know if, because what I would also like to put forward to the viewers is that as a country, we were at a state whereby we consisted of 4 states. I don't know if you know that. We consisted of 4 states, namely the Cape Colony, Natal, Transvaal, and the Orange Free State. That was before 1910. 1910 was 1910 was when we had the formulation of the African Union, you know, which gave rise to the African Union that we have now in the capital city of South Africa, Pretoria. This union was given rise by the South African Act, which was passed in Britain. This act obviously was in bias of the natives and in favor of the colonial masters. And from 1910 until 1993, where the interim constitution was introduced, building up to the 1994 elections. The interim constitution was introduced, and then 1994, the first democratic elected parliament then passed the 1994 constitution. The constitution was only promulgated by Nelson Mandela, 1996, the 18th of December, and it only came to law, or it only applied 1997, the 4th. Until this day, we have had more than 17 amendments on that very same constitution. And that constitution now serves as the supreme law of this country. So historically, we haven't had much wins as compared to the losses, because my major concern as an individual is that the Eurocentricity contained by the legal system, not only of this country, but then of the entire state, you know, because looking at
Sakhile, are you still with us?
laws.
Okay, good.
Were actually passed at the time were actually created not in favor of people of color, women, children, and other social groups and religious groups. So it is of great concern that those same laws have been gathered together, compiled, dismantled, and put together again, and then presented as new laws, only to find that they still possess the same effects as they had back then, you know. So I would lapse there momentarily, and then I will allow the floor to my learned friend, Mr. Katlego, Mashego.
I thank you very much, Sakhile, for that wonderful presentation. I hope our viewers have learned a lot, including myself. We've learned a lot with regards to historical perspective and background to the legal system of the Republic of South Africa. Now we'll be going to you, Katlego. So take us through your own bit of the presentation before we get into the discussion proper.
Okay. Thank you very much, Mohamed.
You're welcome.
Thank you for the floor. Yes, as my colleague has elaborated on the issues, mine actually he was actually discussing the background of this subject. But what I will do, I will explain the legal system that we have in South Africa, and my focus will be more on the courts that we have, as my learned colleague gave a brief overview of the history as to how we arrived to this the legal system that we have as a country, South Africa. So maybe just to as well re-emphasize, we have got 5 sources of law So South Africa is a hybrid country. So we've got 5 sources of law, which the first one is obviously the Constitution of the Republic of South Africa of 1996, which, if you can check section 2 of the Constitution, you will see that it is the supreme law of the land. Then we also have what you call the statute, those written laws that are passed by the parliament and also provincial parliaments and so on and so on. Then we as well have the common law, and our common law, South African common law, is particularly from the Roman Dutch law and the English law, as my learned colleague has explained the background on that. Then when we proceed, we have customary law. Customary law is the indigenous law, which is, I can call it, I think indigenous, if I can say is the law of the indigenous people, I think that explains itself very well. Then, and also this law is, I mean, customary law is protected by the Constitution of the Republic of South Africa. If you can check, if maybe I can just refer quickly to the section, is section 211. 3, which states that, I'll quote for you, the courts must apply customary law when that law is applicable, subject to the Constitution and any legislation that specifically deals with customary law. So customary law is as well recognized by the Constitution of the Republic of South Africa. And lastly, as part of the sources of our law, we've got what we call court decisions. So court decisions are the decisions, previous decisions that were taken by the courts, but then how it works per se is, for instance, as I will explain later on, the highest court that we have in this country is the Constitutional Court. So decisions of the Constitutional Court are binding to the lower court. So the court decisions work in that particular manner. So unlike other countries, we don't have specifically, because when I was following previous live feeds or live videos by our learned colleagues across Africa, I've learned that some other countries have got customary courts. So in South Africa, we don't have customary courts, but we've got general courts that deal with general matters. But depending the matter, if the matter has to be a question of customary law, then it will be interpreted in terms of that particular customary law. For example, maybe if we've got a case of customary marriage, maybe the validity of customary marriage, we can refer to cases such as Bear versus Minister Katlego. Then we've got Mayelan cases and all of those customary law cases. Then the court will apply the customary law to those particular cases. So without wasting time, I think I should as well pass and discuss the different courts that we have in this country, South Africa. Our smallest court that we have is what is called a small claims court. So small claims court is the smallest court that we have. If someone is owing you, doesn't want to pay you money, something less than 20,000 actually. So maybe 5,000 and 10,000, even 2,000, for example. You can approach the small claims court, then the matter will be resolved. And the nice thing about small claims court is that it affords the men on the streets to be able to approach it, because it's not expensive and it's flexible, and the proceedings are usually after hours. So the small claims court proceedings are after hours. Then in that way, it means you can go to work during the day, and in the evening go to approach the small claims court that will be heard. And as on the aspect of saying it's not expensive, we're also looking at the fact that in the small claims court, there is no legal representation that is allowed, which is to say, you cannot bring what you call your lawyer to represent you in the small claims court. And also, the plaintiff in the small claims court has to be a natural person, even though a natural person can take a juristic person or a company also to small claims court, but the plaintiff has to be a natural person. That's why I'm saying it enables a man on the streets, someone who doesn't have money or who has got very limited money, to approach the court and get redress on the issue that they have a problem with. So after small claims court, we've got a magistrate court, which is divided into two. So I will say the second court, we have the district magistrate court, which as well hears matters that are not, I can just say minor matters and other matters as well. But in the district court, you will hear matters that are not above 200,000 rand, and you cannot hear matters such as high treason and so forth and so on. So after the district magistrate court, we've got regional courts, and then recently regional magistrate courts were given power to listen to cases of divorce. So if a person wants to divorce, then they can approach the regional magistrate court. But other issues such as high treason as well cannot be heard in the regional magistrate court. If a person wanna approach courts in such matters, then they have to go to the fourth court, which is the High Court. And as well, I just have to emphasize that in the magistrate courts, both the district magistrate court and the regional magistrate court, one cannot go there to declare a person insane. So such matters of status of a person must be addressed in the High Court. So just a quick recap: the smallest court we have is the small claims court. Then it's followed by the district magistrate court. Then we got the regional magistrate court, and then the fourth one we have got high courts. So high courts, they are in each province, but some other provinces has got more than one court. So provinces such as Gauteng, where I'm currently based, we've got two high courts, the one in Johannesburg and the one in the capital Pretoria. We've got the South High Court and the North High Court. So high courts hear most serious cases, as well as cases such as high treason and declaring someone insane, basically the status of a person. Then after High Court, we've got the Supreme Court of Appeal. The Supreme Court of Appeal, which has got actually national jurisdiction. So as the previous courts actually don't have natural jurisdiction because they only serve for that particular area that they are. For example, the High Court of, what can I say? The High Court of Free State has got jurisdiction in the Free State province. You can't be a resident of Gauteng, or the defendant can be from Gauteng and you choose to go and institute action in Free State, or you can be in Limpopo and choose to go and institute a proceeding in Cape Town. Maybe you want to visit the sea and you decide, no, let me institute action then. It doesn't work like that because of the provincial jurisdiction that we have. So yes, the Supreme Court of Appeal has got national jurisdiction. So Supreme Court of Appeal is approached, it's not court of first instance. Court of first instance means you cannot go directly to Supreme Court of Appeal. You have to come somewhere. For example, let's say you're not happy with the decision of the High Court, any High Court. You are in Western Cape, Eastern Cape, you are in Pietermaritzburg in the KwaZulu-Natal, or in Durban, you are not happy about the decision of that Durban High Court or KwaZulu-Natal High Court, then you can go to Bloemfontein in Mangaung, where the Supreme Court of Appeal is situated, and you can go there and actually appeal your matter. So as I said, it's got national jurisdiction, and also is a court that is not a court of first instance. So all these appeals then can be heard in the Supreme Court of Appeal. Everything into constitutional and non-constitutional matters, criminal and civil and so forth and so on. And then the last court that we have, as I said, we've got small district magistrate court, regional magistrate court, then we've got high courts, then we've got Supreme Court, and the last one that we have is the Constitutional Court of South Africa. So in the Constitutional Court is the highest court in all constitutional matters. So in this instance, however, I have to say that in the recent month, there was this other decision that was passed to say the Constitutional Court can decide on which matters it listens to. But at the moment, for this presentation, I'll say the Constitutional Court is actually the highest court that we have in the land, and is the highest court. If you're not happy with your appeal, let's say you are appealing a constitutional matter in the Supreme Court of Appeal, and you are not happy with that particular decision of the Supreme Court, then you can approach the Constitutional Court. But if the matter is not constitutional, then you will have to actually end in the Supreme Court of Appeal. You cannot go to the Constitutional, because Constitutional Court deals mostly with the constitutional matters of the constitutional matters per se that are brought before it. So so I think I've covered everything, and I think I've exhausted my 10 minutes as planned. Thank you very much. Over to you, Mr. Mohamed.
Hi, thank you, Katlego. That was a brilliant profession, and thankfully you've said everything that we keep asking people on this program. You've mentioned the system of laws. I mean, the sources of laws we have in South Africa. Can you guys hear me? Can you hear me? Hello?
Yes, 100%.
Okay.
Yes,
okay.
yes.
Okay, like I said, in your presentation, you took us through the sources of laws in South Africa, which has been the very first question we keep asking our guests on this program, and then we learned something. To my personal deduction from what you've submitted here this evening is that the legal system of the Republic of South Africa is quite similar to that of the legal system of the Republic of Botswana. I don't know if because of the territorial settings that you guys share borders, but you mentioned the hybrid system, the Roman Dutch law, and then the English common law, and then blended with the customary law. So my first question I will put to you, if we to start the dialogue proper, my first question I will put to you, Katlego, kindly tell us, what if there is a conflict between a principle of law affecting the common law system to that of the Roman Dutch law? Which one will take precedent?
Mohamed, can you please rephrase your question? I didn't get you clearly.
Okay, my question is, what if there is a conflict? What if the Roman Dutch law, a principle in the Roman Dutch law, is in conflict with the common law? I know, because these are hybrid laws, and there are times when they don't converge at all. There are some divergences. So my question now is, what if there is a conflict between these two systems of laws? Which of the laws will take precedence?
Okay, thank you for your question.
Yes.
Maybe in answering your question, Mr. Mohamed, I will have to highlight that our common law in South Africa is basically coming from the Roman Dutch law and the English law. So, for instance, some conflicts that we may see is that we might have a conflict between the Constitution and the common law. So in a case whereby there is a conflict between the Constitution and the common law, then what will be considered will be the constitution, because the constitution is the supreme court of the land. So if there is any conflict of the law, then the constitution will be the one that prevails. And
Okay.
what is written in the constitution?
What if there is a conflict between the customary law and that of the Roman Dutch law, or let me say the common law, which comprise the Roman Dutch law and then the English common law? What if there is conflict with the customary law? Which one takes precedence?
If there is conflict between the customary law and the common
principle
law
in customary law.
Well, I will argue that what will prevail will be the customary law, looking at the particular setting, because the customary law is protected in terms of section 2113 of the Constitution of the Republic of South Africa. So the customary law, I'll say it will prevail.
Okay. Sakhile, do you share your thoughts with that of the submission of Katlego? Do you share these with me? Or do you have a different view to that question?
No. I would choose to share the same blanket as my Leonard friend here. I would choose to share the same blanket for now.
Okay. So you've chosen to share the sentiment with Katlego. That's fine.
Exactly.
But you see, this is my problem with the entire Africa legal system. We claim to have gained independence. Each and every country claims to have gained independence. But South Africa is different from what I've heard from you guys. You go to every other African country, you will see that the English common law, or rather the laws that we are inherited from our colonial masters, those laws take precedence over our custom. And basically the reason to that they will tell you is that because they've relegated our laws so that they are not in consonance with natural justice. But before the white man came, there was a governance in Africa. There was this the Mani Empire. There was empires all over in Africa, and there were laws. What happened to those laws? And when the white man came, they brought their laws. And when they brought in their laws, we started practicing it. You cannot believe we are in the week. They do in England in 2002. If we want to be, if the day we shall be calling, the day we'll be calling to the bar, we shall be wearing the wig, imbibing the culture of the Englishman. And we claim to have gained independence from the United Kingdom in 1961. So I am very pleased with your submissions to know that in South Africa, if there is a conflict between a customary principle and that of the common law, the customary principle will prevail. Kudos to the people of South Africa for that. So in that light, Sakhile, I want to bring you in. Now, in your own perspective, what do you think, or how influential the apartheid system, or the laws during the apartheid regime, how influential those laws, or how influential that particular movement it is to the current set of legal system we have in South Africa? I know we've gone away from the apartheid system, but how influential that whole apartheid regime was in having the current laws that we do have now in South Africa.
Yes, Mohamed. Thanks again for the floor. Firstly, I would quickly rush and then add on your sentiments that you laid upon us a few moments later. You know, that has always been my concern personally also, you know, the fact that foreign laws have been imposed on us, you know, and there has always been this one obvious aspect actually, that Africa as a whole is based or formulated or emanate from customs, you know, customs of the land, and then we then find conflict because now we are at a point whereby we have to determine that do our customs remain constant, or do they vary with time? You know, so the thing is, what is customary today, or what is by culture today, tomorrow will it be the same thing? You know, for example, what has taken the whole world as long one of the most violated human rights, the right to sexuality, you know, and including homosexuality. You know, most African countries have always been, or is against sexuality and same-sex marriage. You know, and now once you bring in the African perspective in that, automatically you will be cancelling rights of a particular group. You know, the same country that might claim that they stand for those rights. So there's always a conflict between customary law and laws of other and laws in which were imposed to us. You know, sometimes it's beneficial because we get to broaden our horizon rather than keeping it collected. Sometimes it's detrimental to the dignity of the state and our people. Going back to your question, Mohamed, how the apartheid has formulated the now current legal system. It actually it is derived from apartheid, the system that we have now. You know, because for it has always been the essential elements in reaching the current legal system has always been freedom, equity, justice, and dignity. And I think as the African continent, we all share that. You know? And the apartheid, the fight against apartheid was to attain those things. And I feel as if we had an ideology back then, and then we fought towards as an established ideology, and which is what we have now. Okay, my main problem with the legal system and the apartheid era is that as I would not say majority, but then there are laws that remain intact as they were before the attainment of freedom. You know, those laws were set, or were structured to oppress. You know, and they still and they are still they are still active until this very day. You know, some laws have not been amended. My learned friend will help me with a few of those laws as I continue with my presentation. And it becomes a problem because we claim to have moved, but in actuality we remain in a constant position, you know, partially, you know, not to say that the entire legal system is still left behind, you know. So I would say the apartheid has kind of shaped the current legal system, you know, in one way or another. We basically the legal system basically emanates from that very same regime.
Okay. Thank you very much for that. That's a brilliant one. But my only disappointment is that the fact that we still have laws that we are inaugurated during the apartheid regime still are present in the laws of South Africa in 2020. But I hope there is a good reason for that. So, and that's why I will bring you in, Katlego. What do you think about that? What's your own view? That why are those laws still in existence? In if they deem to be unfit for purpose, if they deem to be as Sakhile submitted, and they are still oppressive. Why are these laws still in existence in the legal system of South Africa? Why haven't they been relegated into the cauldron and doldrum? So take us through that.
Yes. Thank you, Mohamed, for the question. And I have to say as well that the sentiments that you raised earlier on about the customs not prevailing in most African countries, I actually share the same sentiments with you, and I hope that something will be done in Africa, because I believe that the customs must be the laws that are actually followed, because they are for the indigenous people of Africa, and basically we can have the laws, foreign laws, prevailing over the customs or customary law of our respective African countries. So yes, I agree with my Leonard colleague that there are some laws that are still were not amended. Actually, in fact, there are many. Some I can say I think the reason behind it, I can't actually say what is the reason behind it, because if I remember correctly, and I stand to be corrected, our criminal procedure law, for example, is of 1966, which was during the apartheid time. So there are many laws that are from the apartheid era. I think what just changed can be the system. So, and also what changed mostly was those laws that actually discriminate between blacks and whites and so forth and so on. But then it's true that there are laws that are still in place. And also, if you can check, I don't know if you, Mr. Mohammed, you have learned of the fact that in South Africa now, the constitution, the political party, the ruling ANC and other political parties, they are pushing for the constitution to change, particularly in our section 25, which has to do with what you call property.
Yeah,
Let me
land.
quickly just move to land. Yes. Let me just quickly move to section 25. So yeah. So it's just a moment. So there is a pushing of it that it must be changed, because actually our constitution does not go in favor of expropriation of land without compensation. So there is a fight that the constitution must be amended, and then that the land that was taken unfairly during the apartheid time must be taken from those people that took it without compensation. So as a country, I'm of the view that we still have a long way to go. We still have a long way to go, but yes, and I think as the youth of this country, and the youth of Africa, we have got a lot of work in our hands, and it's up to us to keep fighting and keep fighting for the rights of our people. And also what we see that is not right, we have to make sure that we do our level best to correct it. Yes, that's my submission so far.
All right, thank you for that, Katlego. All right, guys, if you want to be part of this program, you may kindly join by commenting on the Facebook live feed. Hopefully by next week, we shall be giving out a number where you will text. They will read your text, and we'll start doing a calling program when people will call and contribute to this program. We are fixing that as soon as possible. I am joined by two legal luminaries from the Republic of South Africa, Sakhile Mpanze and Katlego Arnold Mashego. Both these guys, I think, are now barristers at law, and that's why you see them calling themselves learned colleague, which we are prohibited as students. If you are a student, don't call yourself a learned colleague. We are not yet learned colleagues. So, but these guys are lawyers. Don't invite them. Yes.
You know why we call each other colleagues.
Yes, I know, I know. I know.
Let,
Of course,
let me briefly explain.
yeah, I was in front of Mr. Katlego's court in the moot court last year in Gaborone. I was in front of his court. Yeah, he was one of the judges, and I think I mooted in front of him. Do you remember me?
You know why?
Do you remember
I
me from
remember.
Sierra Leone?
Yes.
We are mooting against I think it was a team from Zimbabwe, or I've forgotten the team really. I've forgotten the team, but we did moot before you guys. Yes.
I think it's a team from Harare, if I'm not mistaken.
Yes, Zimbabwe, Harare. Yes, yes.
Harare, Zimbabwe.
Yes, yes. Okay. So so guys, now let's go into the institutions. We've got several text comments from the Facebook viewers. Shekuman said, like always, don't mind my view. The monitor is right in front of me here, very big monitors. So I'm looking this way, and the camera is here. So Shekuman said, what a rich history of the origin of the law of South Africa. This is indeed an eye-opener to the understanding to law profession. Kudos to Presuba for this educative program. Sylvester Bandi Biga Fode. Nice move, Wurie, and please continue to provide such platforms to educate us about the various legal systems in Africa and their way of practicing and applying the law. Bravo, praise. I am impressed. All right, thank you, viewers. We stop there for now. Now let's go back to our studio guest. So, guys, let's dwell on the institutions. I know for sure the institutions in South Africa are solid and sober. We've heard a lot from the judiciary of South Africa, the formation of the Constitutional Court, and so many other development of the jurisprudence in South Africa. So now let's start. First of all, let's start with this institution that it has the constitutional mandate to make and unmake the laws. So take us through which institution is constitutionally mandated to make the law, to make laws in South Africa. I will start with you, Katlego.
Oh yes, if I get your question correctly, you want to know about the institutions that are responsible for making the laws.
Yes.
Okay. Yes, the institutions that are making the laws, and we say is the legislature. So the parliament is responsible for making the laws, and when they make the laws, then the public is given a chance to comment. The draft is published in the government gazette, and then the public comments, and so on, until at the very end the president signs it, and it becomes the law of the land. Those are the national laws, and also we in the provincial side as well, same process has to be done. Then the public comments and so forth, and so on. So provincial legislature as well passes laws for a particular province. So for instance, Gauteng can pass law for Gauteng, and also Free State pass law for Free State, KwaZulu-Natal for KwaZulu-Natal, and so forth and so on.
Okay,
you answered.
Yes. Before you come in, I am pretty sure that Africa is not new to the Parliament of South Africa. We are so familiar with that Parliament, courtesy of Julius Malema. So take us through what you wanted to say, Sakhile. That Parliament is so familiar here in Sierra Leone. We most of the time we have to watch the proceedings, and then we are so glad to see the Pan-Africanist Julius Malema taking on issues, and one time even taking on President Zuma. That's a very good one. Okay. Yes. Yes. Let's go.
I see you are very observant over what's happening in our land. Yes, we have a very active parliament. One of the MPs you mentioned, Comrade Julius Malema, who's very active and who's very vocal also, you know. But then the credibility of his activism can only be judged by those who know him correctly. We will leave that for another conversation.
Another day, that one.
Please, guys, let's take politics away from this. Or some people will stop watching the program. Some people will get offended.
Yes.
So, yes. So let's go into the law. Let's focus about politics.
Because if you want to get a fellow South African worked up, you will just try and tease his or her political affiliation. But then back to my submission, Mohammed, I would have loved to add on what my learned friend here was alluding. When provincial legislatures pass laws, like recently, I think on June we were supposed to pass the township bill in Gauteng, as announced by our premier. We were supposed to pass the township bill. Now the catch is is the conflict. You know, when you have multiple legal instruments presiding over a state, you always have an issue of conflict, and to avoid the conflict, you must establish superiority from the bunch, and how can I put it? Okay, the proper term is running away, but then you and what I would say is that the township the township bill which might have been passed in June might not have any conflict with its superior law, so we have to understand the final line there, that the laws that are set provincially are not to contest with those those that are set national. They are just to enhance,
Okay. Um, Sylvester again commented, I believe it's prudent that as African, as Africans, we put our customary laws above inherited or imposed laws like the common law and others, because the common law, for instance, comprises of the common customs among the English, and thus means that we are regulating our people using different customs instead of ours, which they understand better. I think we should really put ours first. I am impressed with the South African way. Indeed, that's what we've said in this program, and it is not only us saying that. Even in the study of jurisprudence, as far as the historical jurists are concerned, Professor von Schabini and his disciple, Professor Puchat, believes that the Roman law will not work for the German people. So what they did was to have the German own type of law. When the United States of America gained independence from the United Kingdom, they went into a complete total way of life. I mean, a complete total legal system, different from that of the English legal system. For us in Sierra Leone, according to history, we've gained our independence since 1961. But up till now, we still have the Lassini Act, which we inherited from Britain in 1916. Up till now, we still have the Offences Against the Person Act, which we inherited from Great Britain in 1861. What are our parliament doing? Why are we still having these laws? The laws that we are imposed upon our people during colonial days, and when to say they accepted to grant us our independence, we still maintain these laws. So it begs the question if really, as Africans or as people, we do have independence from those people. Anyways, we save that for another day. Let's continue the program. I have with me Katlego, Arnold, Mashego, and Sakhile from the Republic of South Africa, helping us to discover and explore the legal system of the Republic of South Africa. So, guys, we've spoken about the legislature, which is mandated by law to make and unmake the laws. And of course, Katlego, you've taken us through the judiciary, the court structure at your earlier presentation, and also did you mention the judges? So let's go now to the judges. Before we go to the judges, Katlego, how does one become a legal practitioner or a barrister and solicitor in the Republic of South Africa? If you want to become a lawyer, how do you become a lawyer in South Africa?
Okay, no. Actually, it's a very good question that you have asked, Mr. Mohamed. So, in order to be a lawyer in South Africa, or I can say an attorney, because we are divided into, to be a legal practitioner, you can either be an attorney or you can be an advocate. So in order to be a legal practitioner in South Africa, you have to obtain what we call Bachelor of Laws, LLB. So when you have LLB, let's start with, if for instance a person wanna be a attorney. So what will happen is, okay, maybe before I give that distinction, I should as well maybe just try to explain what is attorney, what is advocate, so that if we have got laymen around here who live with us watching, they can be able to understand. So an attorney is a legal practitioner that mostly appears in the lower courts, while an advocate is a legal practitioner that mostly appears in the high courts. So before the new act, because we have got now new legal practice act, before that new legal practice act that is in place now, advocates were not allowed to get clients on the streets. That is to say, attorneys will be responsible for getting clients. Then if a matter goes to the higher courts, like the high courts, the Supreme Court, the Constitutional Court, then they will brief an advocate, and that particular advocate will go and represent. And in the past, most attorneys were mostly appearing in the, I think even now, actually, attorneys are mostly appearing in the magistrate courts, the lower courts, and also, but they can apply to appear in the high court, but mostly they appear in the lower courts, and the advocates appear in the higher courts. So if one wants to be an attorney, what they do is you get LLB. Then after obtaining LLB, you can go for 2 years articles. After those articles, you apply to be admitted. So the articles is basically being candidate attorney, working under an attorney, a practicing attorney. Then after a period of 2 years, one gets to be admitted as an attorney. But that period of 2 years can be reduced to 1 year if the said candidate choose to go for law school. Law school, we've got regional law schools. I think we've got about 8. So law school is whereby you are taught for 6 months on the practical aspect of being an attorney. So in that way, then you will serve 1 year of articles and 6 months of law school. Then you are you apply to be admitted as an attorney. So if you want to be an advocate, if one want to be an advocate, you same procedure. The qualification that is needed is LLB. After obtaining LLB, then one has to go for what we call pupillage, and then after that pupillage, then they can apply to be admitted. Then I have to emphasize something which I didn't actually emphasize. After you are done with your, or in the course of the articles and the law school and so forth, one needs to write what we call attorney's admission examination. Then when you pass those examination and you have finished your articles, and if you are doing also law school, you have finished the law school, and then that's whereby you can apply to be admitted. Same with advocate, there are examinations that must be written. When you finish your period of privilege, which is 1 year, then under practicing advocate, then you will be required to be able to, you will be required to write the entrance examination. Then after that, you can apply to the High Court to be admitted. Then after that, you are a legal practitioner, either an attorney or an advocate. Wow. I assume I've answered you.
So such a rigorous process. I don't wish.
Yeah, it's a very long process.
Yes, I wanted to see if I would go down there and be admitted into the bar there, but I've changed my mind with a second thought. With that kind of rigorous process, I prefer to stay here in Sierra Leone and become a lawyer. I've just been.
You just have to have LLB and apply to be admitted, right?
Yes. In Sierra Leone, you have an LLB, and then we have what we call the law school, which is like just the law school 6 months. But as in Sierra Leone, the professions are fused. the legal practitioner's profession is fused. You can become a solicitor, an advocate, and a barrister all together. I haven't gone through the law school, the CIO law school, the 6 months CIO law. Is it 9 months? 9 months you go through the CIO law school, and once you graduated from the CIO law school, you automatically become a legal sorry, a solicitor, a barrister, and an advocate in the High Court of Sierra Leone. Yeah, it's
Oh,
fused.
yeah. No, I think I should move that side to go with that shorter process.
Yes, yeah, you should come. You should come. You're highly welcome. You should come. But so, guys, I've just been notified by my producer that we are almost running out of time. If not, we've run out of time. But before we go, let's go into one more discussions. How with you, both of you, I'm asking this question. This question is for both of you. Personally, how would you rate as far as judicial independence is concerned? How would you rate your judicial independence in the Republic of South Africa? What would you say about judicial independence in South Africa? Is the judicial independence free from interference from the executive or other arms of government? Either of you can start. Yes.
Sakhile, you wanna go first? Should I go first?
No, I'm gonna go first, and then obviously you take on. Well, we do obviously have what we call it legal term trust politician separation of powers. Meaning from the three arms, none is to interfere with the other. Also considering the fact that the South African laws are abiding to every citizen, even those who are responsible for passing them. But then the legal fraternity is one that has multiple elements and it's easily influenced. It's easily influenced. We have here in this country what we known as a white monopoly capital. We one of the major influencers in everything. We also have Stratcom, strategic communication, which can obscure a matter from any direction to any direction of its liking. So I would be bold and answer that question per my perspective and per my discretion as an individual and say that they are hands. Hands come from what directions? Mostly from the political fraternity. They always lend an extra hand, it appears, to assist our judiciary. Something that's not always welcome, but then it's the fact. It's a fact. I've always told those who I've conversed with that it's actually very difficult to separate law from politics. Something that I always tell my dear friend here. He always fights me about that. It's always difficult to differentiate a law from politics. Hence, you will always find that the most influential element in this fraternity will always come from the political side. So yes, we get influence that's undue, duress.
Okay. So let's go to you, Katlego, quickly. Kindly summarize your submission, sir.
Well, I think my Maryland colleague has said enough. So, for the interest of time, I will reserve my submissions.
No, I don't want you to reserve your submission. I want to hear from you. What do you think about the judicial independence of South Africa? We know for sure you cannot take away politics totally from the law, because in fact constitutional law is there to bridge politics and the law. So and as Baron de Montesquieu has once observed, that the three arms of government must work independently, free from influence from the other. So do you agree with Sakhile, based on his submission? Do you share his sentiments?
Well, I think firstly I'll say that I think the judiciary of South Africa is doing a great job under the leadership of Chief Justice Mogoeng, which I admire a lot. So, but then as things stands, we cannot per se. I don't know if you know about the state capture of former President Jacob Zuma. There is always some rumors that the state was about to or is captured, and so forth and so on. But then I think from where I'm standing right now, even though I'm sitting down, is that the judiciary is doing a great job so far.
Okay, before we go, one last question from Sheikh Sheikh Mansari said, when there is a petitions in general, I think this is an obvious question. When there is a petitions in general and presidential election, what court presides over it? I think it's the Constitutional Court, but let's hear from you guys.
Sakhile?
Is it the
Yeah, it has to be the Constitutional Court.
Okay. Right, guys, thank you very much. You've been a wonderful host on behalf of my producer, Madam Mary Theresa Solomon, for bringing this program to you. I want to express my sincerest gratitude to you guys and to the university you guys are representing, and to the fact that you guys are impacting knowledge upon humanity. We want to say thank you very much, and thank you to all the people of South Africa and to the rest of Africa and to all the people that joined us this evening. But before you go, I have a present for you guys, which I've been preparing over the course of this week. Please don't laugh, because it's something I started a couple of days ago, and I want to see if I can start doing it for every other country that will be joining us on this program. So my present for you guys this evening is this: Unkosi seleli Africa. Mayo pakanisu pondondwayo Israeli tandazu yetu Unkosi sikelela Tina Osaponwayo Morena Kasi Shabasa Yesu Israeli. Oh my God, that's why I stopped. Thank you guys. Thank you. You've been a wonderful.
No, that's very impressive. That's very impressive.
No, that's very nice, man. That's very nice.
Until we meet again, I hope to see you guys someday soon. I should come down there again. Those was a wonderful time down there. I spent a little time in South Africa, but it was great. Thank you. Until we meet again, I've been your humble host on behalf of the executive producer of this program, Honorable Justice Abu Bine Kamara. On behalf of our producer, Madam Theresa Solomon, on behalf of the Law Society Executive, on behalf of the administration of the University of Sierra Leone, broadcasting live from the Citadel of Academia, the Mountain of Hope Friday College. I have been your humble host, Mohamed Wurie, the president of the Law Society Friday College, University of Sierra Leone. Until we meet again next week, as we shall be exploring another legal system, another country, I will say goodbye. How do we say goodbye in is it Zulu or Shona?
It's Zulu.
How do we say goodbye in Zulu?
Yeah, I think you asked correctly, because Zulu is one of the most popular language in the entire Africa. But then we are not there.
We've got other languages.
Okay, just say goodbye to viewers.
Siyavalelisa.
Hi, bye, tata. Okay.
All right, thank you.